Today is May 20th, 2020, and as we speak, the New York State court system is open, but is not currently accepting any new filings. As a result, under normal circumstances, we would likely see a ton of COVID-related landlord-tenant commercial litigation. But right now, because the courts are not accepting new filings, all of the cases that we have seen, and there are very few of them, have been in the federal court system. We've seen a few cases filed in the last few weeks with the standard fact pattern that you would expect. The commercial landlord is suing the commercial tenant. For example, in Manhattan, we've seen Gap and Brooks Brothers have both been sued by their landlords for unpaid rent. We've seen a couple smaller, similar cases that have taken place in Brooklyn, that have been filed in Brooklyn. But the case that we're really following the most closely right now deals with Brooklyn Boulders, the climbing gym. Brooklyn Boulders is the tenant, not the landlord, and they have actually initiated a suit against their landlord, seeking a declaration saying that their lease is no longer valid. They're arguing based on the doctrine of frustration of purpose. They're saying that based on the new government regulations and the government regulations that are likely coming in the future, that their climbing gym, their co-working space, and all of their current plans under the lease are no longer viable. And so as a result, the lease should be terminated. It's an interesting case. It's an interesting tactic, seeing the tenant going after the landlord and not vice versa. I'm sure we'll see a lot more of this in the future, especially as the New York State court system opens up. Certainly we will be following along. And if you have any questions, please reach out and let us know. Thank you.